Hello, everyone. Um, this is our fourth week in the seminars. And again, we have two topics today. The first one relates to the purpose of competition law, the consumer welfare standard, the superiority of the consumer welfare standards. When you look at the topic, apparently, you can guess that the Mr. Radic will claim that this standard is better than the others. Well, this became a very hot topic actually for the past 10 years or so, because especially in the US, both the enforcers and some academics at least claim that there are other goals that should be taken into account when applying competition law. And we have practical implications of that approach as well. One can see, in fact, in Europe, DMA can be a legal implication of that strand of views. So today we're going to discuss this, and I believe this discussion also important for us throughout this seminar series, given that we generally refer to this concept almost in like all cases, like perhaps second session in your presentation, somehow we will probably refer to consumer welfare standard. So it's important. It's one of the basic topics, concepts of competition law, and it's good to discuss this, and it has practical implications as well at the moment. So we have Lazar Radic from Madrid, IE Law School. He's an assistant professor there, and he teaches administrative law and competition law, apparently. And he's also an academic at Center for International Center for Law and Economics, where they promote scholarly activities in law and economics and competition law in particular, right?
That's right.
So you have 40 minutes, and then we have discussions. Floor is yours.
Okay.
Thank you for being here. Thank you for coming from Spain.
Thank you for the invitation.
Sharing your views with us.
Thank you, Jem, for the invitation. Thank you, everybody, for coming here, despite the football match against Hungary that's going on right now. As Jem said, 10, 15 years ago, the topic of consumer welfare in competition law would have probably been quite a mainstream sort of approach. Saying that competition law was about protecting consumers was probably the most boring thing that you could say. Today, this is somehow provocative, right? It's actually a provocative title. And it's us who are on the back foot, arguing that protecting competition is ultimately about benefiting consumers, right? So maybe let me give you a little introduction of the state of play and what's going on. So for many decades, as I suggested, the consumer welfare standard was the lodestar, sort of the guiding light of antitrust analysis. Cases would turn on the question of whether a certain practice harmed or didn't harm consumers, right? That's just how we understood whether competition was harmed, as a yardstick, right? However, at least since I would say the 2015-16 mark, especially with a paper called the Amazon's Antitrust Paradox by outgoing chair Lina Khan, the FTC. Ever since then, there was a big contestation of the consumer welfare standard that's actually gone viral. The main claim of the neo-Brandesian school and what we call the critical political economy theory was that the consumer welfare standard was just too narrow, right? That it focused too narrowly on prices, it ignored dynamic effects, and it ignored many other harms of monopolistic companies that antitrust law, with its progressive roots, had been designed to tackle, right? One of those was denying citizens the democratically granted legislative protections against private and political power, right? However, despite the influential appointments, of which, as I mentioned, Lina Khan was one, Tim Wu was named special advisor in economics to the White House. He's also a prominent neo-Brandesian who brandished this theory. The critical political economy theory, despite the rhetoric, despite the prominence in policy, and some of you have probably heard about this and have listened to the neo-Brandesian speak, ultimately the transformation in policy and in law just fell a bit short, right? So in a sense, there's two things that are going on that seem to be contradictory. On the one hand, There's a lot of influential rhetoric about moving past the consumer welfare standard, about how the consumer welfare standard is not fit for purpose in the digital age, how, it's strayed from the progressive path charted by the Sherman Act. But at the same time, it is achieved so far. We don't know. Maybe its impact will be felt in the years to come. And again, maybe Trump's administration will follow in those footsteps. But the truth is that in terms of the law and the policy, even the cases that have been brought by Khan's FTC were relatively vanilla. Vanilla in the sense that they were quite mainstream and tethered to consumer welfare, despite the rhetoric. So our paper sort of happens against this background, and we try to assess why this is the case. Why, despite the attractive rhetoric, the legal and policy changes wasn't there. It kind of fizzled out, for now at least. Here are our arguments. The first one is, we talk about the successes and the failures. We can break them down like that. So the first argument is that the neo-Brandisian critique worked because it embraced a political story that was too attractive. It was very attractive, and it occurred in a time of sort of post-capitalist or capitalist contestation spurred by the financial crisis that probably coalesced somewhere around the 2015 mark. So that was a success. That's why the rhetoric was so appealing to many, especially in the US. The second argument is that the critique failed because it clashed against historical facts. And I will explain what we mean by that. The third one, and our third argument, which kind of follows from 1 and 2, is we anticipate that further contestations of the consumer welfare standard, grounded in politics and maybe even in economics, will likely also hit a brick wall. Why? Because the consumer welfare standard, ultimately, when you break it down and when you ask yourself, what is it? What does competition law mean? And what does competition law protect? Through the sort of, successive cleansing of judicial precedent and legislative action, the answer that you're left with is that companies compete to satisfy consumers. That's the consumer welfare standard, right? And you can try to make it about protecting small companies. You can try to make it about the competitive process, whatever that means. You can try to make it about a deconcentrated market structure, but all those things are ultimately incompatible with competition. And you can stray a bit from the path, but ultimately you're going to come back to the conclusion that consumer welfare standard is a pretty good way to assess competitive harm, right? That's my provocative statement. Okay, so let's start from the first argument, which is why the neo-Brandisian and critical political economy theory worked. What was so attractive about it? What was new? We've had contestations of the consumer welfare standard for a long time, since at least the 70s and the 80s when it became prominent. So what was new about this one? So Robert Schiller coined the term economic narratives, as some of you might know, and these are simple, compelling stories that resonate widely. They're intuitive and attractive, right? The critical political economy theory narrative frames the consumer welfare standard as a sort of neoliberal ploy that benefits big business and harms the little guy and democracy. It's not entirely new, as I anticipated, but what it adds to the usual contestation are three things: provocation, conspiracy, dead people, hope, and, of course, money. Provocation. Unlike other contestations of the consumer welfare standard, this one isn't technical. It is technical, but it's not just technical. It's not saying that the consumer welfare standard should be adjusted like the post-Chicagoans say, or the neo-Chicagoans, or even the Ordo liberals. It sort of says that the consumer welfare standard itself is the forbidden fruit. Like the consumer welfare standard is the problem. This is a provocative statement. Although, today, more and more, it's being talked about and accepted, it was originally a very provocative statement. And for those of you that are new to competition law, for 20, 25 years, the consumer welfare standard was sort of established, enshrined, and we weren't talking about these fundamental philosophical contestations. It was a technical discussion, right? But the neo-Brandisians said no more. Conspiracy. The change here doesn't occur through piecemeal sort of improvement of the law. It occurs through a sort of political coup, right? The story goes something like this. Neoliberal elites, through Robert Bork and the Chicago School, influenced judges, especially conservative judges, and convinced them that competition law wasn't about protecting small companies. It wasn't about a deconcentrated market structure, other goals. It was purely about economic efficiency and consumer welfare. The conclusion being that many big companies are efficient and therefore we should leave them alone, right? So it benefited big business. That's the story. Dead people, of course. We have a villain, we have a hero. The villain was Robert Bork, who wrote, I think it was 76, The Antitrust Paradox, where he criticized sort of the haphazard way, the contradictory way in which courts had been deciding antitrust cases. Sometimes it was about protecting the small guy or protecting the concentrated markets, like in Brown Shoe from 62, right? That was a case in which a merger that would lead to a 5% market share was prohibited because it would eliminate a competitor, right? On sort of the theory that it would lead to concentration, a case that would have been decided entirely differently under the consumer welfare standard. Other times he said antitrust was at war with itself. I think I lost the mic. Right. Oh, here it is. Sorry about that. Can you hear me?
Yeah.
Other times, it was difficult to anticipate what the outcome was going to be because the policy was at war with itself. If the point of competition law was to prevent companies from eliminating others, then a lot of efficient conduct that results in efficient market exit should probably be condemned. Hence his conclusion, antitrust law, a policy at war with itself, right? This was the neoliberal Bible, according to the neo-Bernaysians, right? And certainly it was a very effective contestation. Another element of the neo-Bernaysian critique was that if sort of change had happened in the 70s for political reasons, out of sheer political will, then it can probably be undone through political will as well, right? This is a faster and a quicker response than piecemeal legislative reform or, judicial precedent, which would take years. So the neo-Bernaysians said, you know what, we have to legislate this out, right? So the way it would sort of exit the system in the same way that it came to be. And of course, the last element is money and the claim that Robert Bork and other influential personalities used power to sort of convince, or economic power to convince the courts of their thesis. Now, the main, I think, attraction, or the main sort of element that sets this story apart is that it tied into a broader narrative about neoliberalism, which claimed that since the 1970s, there was a big shift from Keynesianism to something else, something different, what we call neoliberalism, that led to sort of a supreme accumulation of corporate power, the kind of which the world had never seen before, right? And a very smart move from the perspective of the critical political economy theory in the neo-Bernaysians was to link their antitrust critique to this broader movement. This broader movement already existed and was there in academia for, decades, but not decades. Yeah, maybe 10, 20, 30 years. But it had never really seeped into antitrust. The antitrust discussion was mostly technical. There were some historical and political elements, but the contestation was not eminently political. From this moment on, antitrust it's framed differently. It's framed as a struggle between capital and labor rather than efficiency and competition. It sort of depicts the consumer welfare standard as the reflection of that neoliberal political economy that came to be in the 1970s, right? What they're saying is basically, everybody knows about the neoliberal shift in the 70s. Well, in antitrust, this is the form that it took, and it's the consumer welfare standard, right? So they already have a ready audience that is amenable to that message, which was a very smart move. Of course, there's another part of the story which seeps into antitrust of the neoliberalism story, which is economization. In the same way that the neoliberal revolution of the 70s turned the citizen into a mere consumer, turned us all into consumers, in the same way the consumer welfare standard jettisoned, it excluded all these other considerations like political power, which would affect the citizen, for example, protection of small enterprises, and so on, purely treating us as consumers, right? And the consumer welfare standard, again, is the way that this worms its way into antitrust law, right? I can't overstate how much this captured the attention of academia, the press, and politics with its bold, clear messaging. Like, this is a very, very attractive message with a ready audience that now saw in this sort of technical manifestation of the more general theories that they had become familiar with. This is an example. I believe in the New York Times. Be afraid of economic bigness, be very afraid. In the 1930s, bigness contributed to the rise of fascism. We're alarmingly we're experimenting again with a monopolized economy. This was by Tim Wu, who is, or who was, I mean, he's a very prominent scholar. You might know him from the master switch. You might know him from coining net neutrality, the term. He was also one of the prominent neo-Bendesians that I mentioned earlier, was named a special advisor in economics to the White House, right? The idea was, and here I think it's encapsulated perfectly, the consumer welfare standard ignores other dimensions of power that are not economics based, and therefore could eventually literally lead us to fascism. And if we look at the history, such as the Third Reich, we can learn how to anticipate sort of that problem and react in due course. Another example that sort of shows this struggle between sort of capital and labor on the other hand. So the story is antitrust law has been focusing only on, has been ignoring monopoly and labor markets, and has been focusing on other markets. And in fact, it has been more accommodating of capital and business than it has on workers. So this is the attractiveness of the critical political economy theory story. Now, let's move on to sort of an alternative theory. So the idea is that, you know, politics was the main driver of the consumer welfare standard. What Nicholas, my co-author, and I suggest was that there is a dissonance between this story and the history of antitrust law. So why did the critical political economy theory fail? One, it approached the consumer welfare standard as a political ploy, but it ignored the possibility that the consumer welfare standard might actually be a result of the natural evolution of the law, of the piecemeal evolution of the law and of judge-made law in a common law system where precedent is important. Another part of the story is the critical political economy theory argued that the consumer welfare standard was inherently anti-enforcement, that by sort of accepting the consumer welfare standard, it's sort of a Trojan horse, right? Because once you accept it, it is inherently sort of biased against enforcement. Okay, so these are the two arguments that we can test. So the first one. The critical political economy theory presents, as I said, the consumer welfare standard as something that is a bit of a plant that came out of nowhere and that distorted antitrust progressive roots, right? But really, it's true that the 1970s led to a rationalization of the law and an increased focus on consumer welfare. But if you look at it, there are clear traces of what we would call today consumer welfare, focus on prices and output, and innovation prior to the 1970s, prior to neoliberalism, right? So let's look at the early case law of SCOTUS, of the Supreme Court of the United States. If you look at Northern Securities in 1904, this early case, so 14 years after the inception of the Sherman Act, recognizes that the law is an economic question. Ultimately, it is an economic question. 1911, American Tobacco, where monopoly is defined as controlling prices and depriving public benefits, which are associated with those low prices. 1912 to 1920, what we could call the pre-ideological era of antitrust. Supreme Court cases often reference consumer interest, power over price, and raising prices to consumers, Central Lumber, Chicago Board of Trade, and so on. Even Justice Brandeis, who the neo-Brandeisians take their name from, said in Chicago Board of Trade, a case from 1918, that allowing restraints were to be allowed if they didn't increase consumer prices, which is basic consumer welfare logic, right? We can go even further and look at the common law foundations of the consumer welfare standard. In 1895, in Knight Co., Justice Harlan, no less, cited common law as favoring competition to ensure low consumer prices. In Addison Pipe, which was authored by Taft, it was held that contracts restraining competition purely to enhance prices were illegal. Standard Oil incorporated this logic in antitrust law by claiming that only unreasonable restraints of trade that led to price hikes and prevented output expansion were unreasonable. We can go even further back to the English common law. 1610, King James, the first book of bounty, condemned monopolies that raised prices or harmed trade. 1612, Darcy Allen, the famous playing cards monopoly case. Lord Coke, a famous English jurist, wrote that in that case, monopoly was condemned because it increased prices, reduced quality, and displaced trade as sort of relevant harms of monopoly. The 1624 Statute of Monopolies, even though it's often understood to be about innovation, is actually about limiting harmful monopolies, especially those granted by the state, right? Now, the question is, if the consumer welfare standard is a neoliberal ploy, were these older foundations of English law also, in a sense, neoliberal? Probably not. So, the claim is not that antitrust law was clearly about the consumer welfare standard from day one. There was a lot of zigzagging. There were a lot of cases. We mentioned Brown Shoe and others that seemed to look at other goals and objectives. For example, Trans-Missouri, 1897. It used consumer welfare rhetoric, but also worried about corporate consolidation as sort of a problem in and of itself. DuPont, 1956, focused on price enhancement and competition. But in Brown Shoe, which is what we mentioned, small business survival was prioritized over price effects. In fact, there the court said, if we have to make a trade-off between prices and consolidation, we will make it. And if it leads to higher prices, but in exchange for that, we get a less concentrated market structure, then something that not only we can live with, but it's a decision that Congress made when passing the Sherman Act. So what is the problem with the critical political economy theory of antitrust law? The first one is that it overstates the break from antitrust history of the 1970s and of the Chicago School. The consumer welfare standard, in a sense, the focus on prices and output existed long before that supposed neoliberal turn of the 1970s. And yeah, there is definitely a greater focus, more laser focused sort of, analysis on the consumer welfare standard. But it's also true that the law had been evolving in that direction probably for decades. The second reason why we think that the critical political economy theory was strong on the rhetoric, but failed to ultimately dislodge the consumer welfare standard, at least for now, is because in reality, the consumer welfare standard is not inherently biased against enforcement. There are two key assumptions that build on this theory. The first one is that the consumer welfare standard focuses merely on price and that proving anything else is nigh impossible. The other one is that it ignores non-price factors such as innovation or anything else. Now, contrary to the critical political economy theory belief, there have been many price-centric cases, even in the comatose period of antitrust. That's roughly the period from the 1980s to the 2000s when supposedly neoliberalism went rampant. For example, 1978, National Society of Professional Engineers found price suppression among engineers unlawful with no need to elaborate for an elaborate industry analysis. Catalano from 1980, the court here, interestingly, gave more weight to short-term indirect price increase than potential long-term decreases in the invoice price, which is the typical pro-enforcement attitude. Now, the other part of the theory is that the consumer welfare standard ignores any other non-price harm, right? And therefore stifles and undermines enforcement. There is an alternative to that, which is that in a judicialized system where you need to show proof of harm, prices are easier to measure than innovation, right? Short-term price hikes are easier to measure and to demonstrate that long-term changes to innovation or to product quality, which are inherently subjective, right? So, this is granted a less attractive premise than talking about politics, but courts ultimately, despite what we might think, are led by the desire for legal certainty, and they don't really love discretion, right? The consumer welfare standard and the possibility of measuring prices offers a way out of that discretionary hurdle, right? Okay. So the interim conclusion to sort of the reasons where the critical political economy theory of antitrust failed is that the claim of weak consumer welfare standard enforcement is not really supported by historical cases. Of course, we can ask the question of how much enforcement is acceptable or desirable. Sure, there could be a way to ramp up enforcement, but the question is always, how big should antitrust be? Right? It could be bigger, but is that the social optimum? Now, the third part of the paper is sort of a hypothesis on why, despite this zigzagging and despite these changes, enforcers and courts consistently return to the consumer welfare standard. Right? Like, what is it about the consumer welfare standard that makes it attractive or quote unquote superior? Here's what we think. It limits judicial discretion. Despite what we might think, judges actually dislike discretion, and they actually face significant challenges in applying the Sherman Act. Why? The statute, the Sherman Act, those of you that are familiar with it, has extremely broad language that, taken literally, would probably prohibit every restriction or every even contract, right? Again, it prohibits restraints on trade. Generalist courts generally lack economic expertise. And there's another element that is unique to antitrust law. Well, maybe not unique, but especially sort of important, which is that the facts are usually murky. Most of antitrust conduct, or most of the conduct that falls within the purview of antitrust law, is ambiguous, right? You are not always sure whether the conduct that has resulted in the exclusion of a competitor or that restricts competition is a good restriction that promotes competition in the long run, or it's one that purely benefits sort of the parties at the expense of the consumer. And therefore, analysis is necessary. If to the question of effects on consumers, you incorporate other sort of filters, not only is it harder to assess damage, but you also put the court in a situation in which they have to juggle these different goals and prioritize them, right? In conclusion, the consumer welfare standard provides a sort of structure guidance. It provides an elegant inquiry that tethers sort of antitrust responsibility to the question of whether prices are being increased or not. So, there are, of course, and the consumer welfare standard is not perfect, but some of those critiques actually show why it's superior to the alternatives. The first one is that the consumer welfare standard offers and allows for explicit trade-offs rather than vague legal interpretations. It allows you to balance short-term price increases with long-term R&D gains. Of course, most of the time, there's going to be a preference for the short-term sort of price increases or decreases because they're more readily provable. The long-term R&D gains are difficult to prove and difficult to demonstrate. The more you move into the future, the more you need a crystal ball and the more you need to speculate. And, maybe I should go here. Another sort of advantage of the consumer welfare standard is, let's look at, for example, think about the competitive process standard. In a sense, talking about the competitive process as the goal of antitrust law leads to a circular sort of situation in which the process itself leads to a dead end, right? You say that something harms the competitive process, but what is the competitive process? And how do you know that the competitive process is yielding sort of results? The consumer welfare standard allows us to resolve that with a clear yardstick, a measurable yardstick, right? So what is the conclusion of, at least so far, of our analysis? The Neo-Bernaysian critique, or the critical political economy critique, led to a useful reflection that we hadn't had, a conversation that we hadn't had for decades, probably, in antitrust circles, which is assessing the fundamentals, right? The foundational principles of the discipline. And yeah, in a sense, it led us to admit that competition law, in a sense, is political. But so is any economic system. In a sense, the choice of having an antitrust law is political, like any choice of an economic system is political. Having a liberal market economy it's a political choice. And perhaps sort of the reality is that if you're going to have an antitrust law to underpin a free market economy, you're ultimately going to be led to a situation where you need to ask yourself, okay, what is competition and how do we protect it? And there, you have several possibilities. You can talk about competition on the merits. You can talk about competitive process, which are things that courts often measure and mention. But without a way to measure whether the competitive process is being respected, and without a yardstick to measure and to differentiate competition on the merits from the opposite, it's hard to resolve that conundrum. And that's where we think that the consumer welfare standard shines for its predictability, right? And in a sense, the understanding is that the reason why the Neo-Bernaysian critique failed to transform the law and the policy is probably a reason that other contestations that make similar claims will also fail in the future. Okay, that's it.
Thank you very much. Thank you for this wonderful presentation. So should I turn to the floor? Do you have any questions? Well, we'll proceed with you.
Hi. So first of all, I'm an economist. I'm not I'm from the profession of law. So the question that I'm going to ask will be from a different perspective, maybe. But so I'm also coming from Chicago School of Law, Chicago School of Economics notion, and I would like to ask you the one thing. So when in an economy like US, the producers have overseas operations.
Have what? Overseas?
Overseas operations. So this means they produce here and they produce there. The consumer welfare standards might lead you to a point where that's not good for the consumers, and some of the producers are increasing their monopolistic power or their market power. But at the end, I mean, when we look at from an economic point of view, so we're maximizing utility, we're not looking from a law perspective, these overseas operations will gonna have spillover effects in terms of total welfare standards. And at the end, they will have some spillover effects on consumers, which will not be able to be captured from a closed economy perspective. So do you think that these consumer welfare standards capture these kind of dynamics in all open economy settings? How do the regulators look at these issues when they are trying to figure out these kind of applications?
So let me understand. Let me get this straight. So the question is whether the consumer welfare standard captures also cross-border harm, or
yes. So the producers have operations, something that seems to be some kind of market dysregulation seems to be harming the consumers at the first place, but overseas operations, which this market power captured at the local, is actually helping the consumer welfare at the end, because this is something that started to be talked recently. I mean, that's what I read from the literature, where US technology markets especially is not that much regulated in these days. Markups are quite high and they have quite high market power, which is somewhat affecting the consumers in a negative way. But the reason for that is this market power are giving them an advantage in the global markets, which at the end benefits the consumer.
Right. So in the short term, it harms them at home, but ultimately.
You might think it this way, yeah.
So, but ultimately it goes around and it actually benefits them because competition is global.
I don't know this short-term, long-term thing because how simultaneously this benefit is coming back. But at the end, this market power is affecting the consumers from a different perspective.
Right.
From the spillover effects, but because these profits are repatriated back to the country and so on and so on.
Is it more of an industrial policy question?
So I'm thinking, I'm from an economist point of view. So I'm trying to maximize the utility of the consumer. So this is something maybe different than the consumer welfare standards. But what I'm thinking, so that's why I'm saying that maybe from a legal perspective, the only thing is trying to be competitive in the local.
Yeah.
The consumer, it is in the US.
In the US, yes.
Yes, not global.
What was that, sorry?
When he mentions consumers,
right?
In the US, he's mentioning the consumers in the US.
Yeah. I mean, ultimately, sort of the inquiry is, I mean, I think it's also a jurisdictional issue, though antitrust authorities generally do take a broad sort of approach to markets, especially digital markets, right? So, it's true that sometimes the market is understood to be the market of the European Union, although arguably it should be broader. And if you take a broader approach, perhaps that market power isn't as sort of as abrasive, as problematic as it seems. But I don't see a reason why the consumer welfare standard itself, sort of as a framework, would change because of the cross-border nature, I guess. Are you thinking of an alternative standard, like total welfare?
What I'm saying is consumer welfare standards, are they capturing, I don't know these details, are they capturing these spillover effects from the overseas back to the country? That's what I'm saying.
Yeah, I guess maybe not strictly, yeah.
I mean, if I get correctly, I mean, for example, Google, maybe consumers in the US will be worse off in the near future because Google, let's say, increase prices or reduce innovation. But because Google earns from globally, then in the end, it will make investment in the US. So consumers will be better off in the long run.
Right.
The question is this: it's not about global operations or multi-jurisdiction.
I don't think that this. Yeah, I think that what you're describing, I don't think it's usually part of the structured antitrust analysis, unless I'm mistaken, Jim. Is it something that's taken into account?
So these are there are certain benefits. Well, what I understand at the first part was that I mean, if you're operating globally, you have benefits in certain countries in the world, but you have, some negative effects in your country. But then in the long run, or in sometime in the future, with indirect effects, so your consumers can benefit from it. Strictly, I mean, yeah, maybe total welfare, but the problem is I think one of the proof and the measure of these benefits. I think the agencies will face hardship in measuring what kind of benefits that the consumers will get from these actions. That would be the they can in theory, but it would be very hard to prove that these indirect effects will somehow turn to them. That will be my answer.
I mean, I feel like this is a bit more in line with the national champion rhetoric that we're seeing more in Europe. So in a sense, maybe, letting go of the consumer welfare standards for a while so that you get maybe a stronger international competitor with the view that, in the long run, this might actually be more useful. So I think it is, in a sense, not very, doesn't sit very well with the purely consumer welfare. And I think it is, to some extent more politically popular now but not super popular with like orthodox competition law theory.
Thank you. About this again, for example, under Article 1013, when we make exemption analysis, also under Article 4 of the Turkish Competition Act, the consumer which are affected badly from an agreement must be the same consumers who will benefit.
Yeah, exactly.
Therefore, I mean, if we consider long-run effect, we cannot prove that these consumers negatively affected will take this benefit. For example, in the US, GDP may increase, but maybe 1% of the population will benefit from this. So in competition law, we cannot consider this under the consumer.
Yeah, out of market efficiencies or other consumers. It has to be the same consumers that are harmed are the ones that have to be benefited if you want an exemption or if you want that agreement to be considered legal. Right, so it is narrow, and to connect to sort of the impetus of the presentation was that, you know, it's about what's demonstrable. It's about what you can prove, right? And in a highly judicialized system, such as the one in the US, there's always going to be a contestation. So if it's easier to prove price than long-term dynamic, you know, benefits for those consumers, that's what's going to predominate. And perhaps that's the reason why we're seeing mostly price cases and price harms, because that's what's easy to prove. Not because there's some sort of, you know, political sort of for, you know, short-term price increases or decreases, but because of something that's easier to prove than something else.
And that perhaps may create bias against, you know, price versus quality and innovation. And
yeah, and quality is sometimes quite subjective.
Yeah.
Right. And trade-offs are hard to make there.
Again, the same or the new question?
No, completely different topic. So thank you very much. And your this was my PhD topic, so it brought back lots of memories. So in your presentation, quite understandably, you focused very much on the US. Yet your conclusion is universal. So I just want to ask you what you think, how much of this do you think would be applicable to the EU? And with that, I have in mind, I don't know if you're familiar with the work by Stylianiou and Iacovides, in which their empirical work in which they look at more than 3,000 documents, decisions, etc. And one of their conclusions is that EU competition law seems to protect competition as a process rather than out competition.
What's that?
But I mean that I mean, so do you think that I mean, with examples like that, can we say that this is a universal sort of this is something that a goal that shines at a universal level?
Yeah. So the first part of the question, no, I don't think we can conclude that. It's probably overclaiming. And we did focus in the US, and based sort of our analysis of why we think the consumer welfare standards, which was the highly judicialized system, the evidentiary sort of the you know, the more technical, then our hypothesis would be that it's probably going to succeed in other similar systems, right? But no, we can't sort of categorically reach that conclusion. So it's a hypothesis that follows from an analysis. It's still tentative. As far as the Stylianiou and Iacovides research, yes, I'm somewhat familiar with it. I think that their analysis is mostly quantitative and looks at keywords, right? There are often obiter dicta, right, in these judgments. So a lot of things are mentioned, but what ultimately adjudicates the case? Ultimately, what adjudicates the case in the European Union is whether consumers are harmed or not. So the process in itself, yes, but it is circular, because when has the competitive process been harmed? What is the competitive process? I guess one of the slides talks about what other standards, their shortcomings. And one of them is circularity. That, yeah, we can talk about the competitive process, but without something to measure it, How do you contest it? How do you show harm, right? I guess that's the response.
From your presentation, I understand that when you say superiority of the consumer welfare standard, it's like it's superiority in all cases without any exception. And in my opinion, and from what I read and gone through, I think that there are also some authors, some academicians who suggest that while consumer welfare standard is the best standard, in some instances, it might have some shortcomings, and there might be some other goals that can be pursued by the competition law or integrated in competition law that can complement it in certain instances. And most importantly, I think the most critical presumption of consumer welfare is that consumers are rational and that they make the best choices. That also contributes to the overall welfare, not only in the short run, but in the long run. But now that we have some other disciplines like neurology, behavioral economics, much more quantitative psychology, it shows that in some instances, consumers and people are not rational, and the choices that they make can have drastic long-term effects. And I suppose that some of the people argue that consumer welfare standards should not be abandoned altogether. But in some instances, it should be assumed and with proof that the consumers can have some negative outcomes. So there should be an external authority which is the state, obviously, that identifies new goals there and shapes this policy based on these goals. Now, that approach obviously has problems in terms of predictability and legal certainty, where the consumer welfare standard is always the winner. But I think the trade-off can be worthwhile where the potential negative impacts are so high, like if they're fat tails, then in those instances, it might be more, at least it should be considered whether for those specific cases, we should question the assumptions of consumer welfare standard and if we should aim for some other goals based on the findings of other disciplines than the classical economic theory.
Mm-hmm. Yeah. So you can have a consumer welfare standard that also incorporates behavioral economics, right? So you can have a consumer welfare standard that looks at things like price or choice or quality and says, we can't trust choices of consumers because they're irrational, but we should trust choices made by enforcers, which they're also people and they can also be irrational, right? I guess, so the first part is that could be compatible with consumer welfare. And I guess the question then would be, which other goals should we then incorporate? Does that speak to? Which other goals does it call for, in your opinion? Yeah. Yeah, I can hear him.
Let's say, for example, sustainability, for example. What I understand from consumer welfare theory is that basically it says output maximization is always great, but I don't know if you would agree with that, but that's what I understand. So in some instances, we might consider that output maximization is not the best outcome in that specific market because of larger sustainability goals.
Sure, but then we should legalize cartels.
Or
favor monopoly.
Maybe. Yeah,
we can do it. I mean,
maybe, yeah, in some instances.
But then we're thinking about a different political economy.
Yeah, exactly.
Then we have bigger questions.
Exactly, and that's exactly what I'm trying to say. When we are talking about different political economy rationales and where there's justification to do that, I think the consumer welfare theory would be incompatible. And still, competition law plays a major role in terms of the outcomes. So if we have a need to change the perspective on the political economy side, then we should also change the application of competition law on that instance, and there we should be open to new goals. Or should we say that because it's more predictable, because it's more transparent and legal certainty is higher, we should never give up that standard and we should never change our perspective in terms of political economy. Is that what you suggest by saying that consumer welfare is always superior?
I think that it's superior under the assumption that we want liberal free market economy generally, where it's up to consumers to decide which companies win and lose out, and not necessarily a paternalistic enforcer, right? If you want, or if you think that the enforcer should override decisions made by consumers, then I think we're talking about a different political economy. And then sure, everything's open, all standards. In terms of sustainability itself as a goal, I'm not sure that that's something that consumers are unaware of or can't make, right? Consumers are more and more sophisticated and more aware of sort of the benefits of sustainability, right? So those that do want to make that choice, I think they can, and they are making it, right? As a dimension of product quality, right? And it has in some cases. There are some cases in Europe. What was it? CICIC. It was CECC was the washing machine case, I think. Sustainability was mentioned as sort of a feature of energy efficiency of new washing machines. Now the question is whether sustainability could have, on its own, sustained that case. Without sort of the savings for consumers in terms of energy efficiency, right? So far, there are cases, and there have been guidelines that have been published indicating when could be exempted under Article 101(3), right? Along those lines, right? So it can be incorporated, I think, into consumer welfare, but it isn't an absolute, right? Because if it was, like you suggest, if sustainability is the absolute goal, right? Then maybe what we want is more cartels and monopolies. But then if that's the question, I think we have to maybe abandon more principles than just antitrust law, right?
Yeah, I mean, exactly. I mean, as a final word, and I'll give.
Yeah.
I mean, I think that's also a question that should be asked if we are going to discuss consumer welfare standard. I think we should also discuss, and I think the neo-Brandeisians, at least some of them, do discuss that as well, sometimes explicitly, sometimes implicitly.
Let me be, sorry.
Just, I mean, in terms of the incorporation of in consumer decisions, there are many studies which says that when asked directly about the outcomes of their decisions, the consumers do choose sustainability, but when it comes to monetary decisions, they don't. And the monetary decisions that have impacts on future generations, which are not incorporated into their decisions. And when we just focus on the consumers that will make these decisions and leave the floor completely to them and disregard the impacts on future generations, then it's also a problem which the consumer welfare standard currently, I think, is unable to provide any response. That's so in those
you could
instances,
look at long-term effects, right? But then again, it's a question of evidence, because if you want to look at those long-term effects, the question is what you can prove. My sort of theory is, I mean, I agree with this philosophical discussion. I think it's an important one. But ultimately, the reason why the consumer welfare standard wins out is that it's, short-term price increases are provable, are easier to demonstrate. If you talk about long-term sustainability impacts on future consumers in 20 years, sure. But it's something you need to prove. And it's also something that you need to assess against sort of short-term price increases and how you're going to weigh those two things, right? Sorry. Yeah.
Yeah. Well, thank you for the engaging discussion. I think it's a really good topic, and I think we should spend a little bit more time on this topic. And my question is, consumer welfare approach, I think, fails to capture the R&D and innovation in a way, and it has served for a long time in a very good manner. But the way the markets are structured today, maybe it can be something more. And the way we discuss this is it's like either this or that. But can't harmonize these approaches and I'm asking this maybe at the expense of legal foreseeability, but what do you think about having different approaches for different market characteristics? For example, for traditional markets, prices are still good indicators, and very well. We know that tested and or stood to time or test of time and everything else. But for digital markets, it's a different story, and R&D is more important. And Europe is trying to and trying to develop a separate approach for that. So at the expense of maybe again legal foreseeability, what do you think about developing different approaches on the goal of competition law at a policy level for different market characteristics?
Right. If I understand the question correctly, is should we adapt the kids and realities, right? Yeah, sure. I think that there have been cases where the authorities.
Labor market, for example.
Sorry, what's
The
that?
labor market that we have in Turkey.
Yeah.
I mean, we already discussed today in the afternoon that Turkish Competition Authority has a rigorous enforcement policy in labor markets. And when you think this in terms of consumer welfare standard, it's hard to reconcile these two.
Yeah.
I mean, this approach with that standard. I'm not saying that Turkish Competition Authority is in favor of consumer welfare standard. I don't know what standard they really have adopted. They have adopted, but this is, for example, it's not easy.
Yeah, unless the consumer is understood there to be the other trading part, which I think sometimes in Europe it is, like for input markets, it is. So like the consumer is not necessarily the end consumer, right? Sorry, to answer that question. There have been cases, admittedly fewer, probably because of the evidentiary hurdles. But there have been cases, I think, where R&D was looked at, even before the supposedly new markets, sort of the big tech markets. In '99, I think Intel sort of R&D and innovation was the theory of harm in the US in the Intel case. There have been others. I think there's nothing about the consumer welfare standard that forecloses the avenues to dynamic harm. And in fact, a huge part of the literature right now is trying to understand how to incorporate capabilities analysis and dynamic efficiencies into antitrust analysis, right? And sort of the wall that people keep hitting is, how do we operationalize that? It sounds great, but how do we apply it in practice? How do we apply that framework? At the policy level and at the case law level and at the level of sort of making your case before a judge, right? So yeah, I agree, and I don't think that it's something that necessarily calls for jettisoning or throwing out the consumer welfare standard, but maybe it's more of a piecemeal sort of improvement that I don't think is incompatible with the ethos of the consumer welfare standard.
Okay, there's one more question on chat.
There's many questions.
This is the last one, so I know that you're tired. Is it fair to say that the consumer welfare theory also calls for less state intervention in markets?
Okay.
And again, it continues. Can we argue that?
Well, I can answer this maybe quickly.
All right, you can read.
Okay.
Right?
Yeah, I can read. I can still read. I'm tired, but I can read. Is it fair to say that it calls for less state intervention? I would say compared to what, right? Before the debate, believe it or not, the consumer welfare standard advocates like Robert Land and those guys, consumer welfare standard was the more intervention approach. The less interventionist approach was considered total welfare, right? That would look also at producer surplus. So I would ask, compared to what, right? Of course, it's less interventionist than, I guess, a neo-Bernaysian critique that incorporates, many reasons. So deconcentrated markets, political power, and all these other things. Yeah, sure. It's compared to what?
All right. I think
probably.
It's already 8 o'clock.
Probably, yeah. I would say.
Probably the answer.
Yeah.
All right. Thank you.
Thank you.
That was great. We asked too many questions, perhaps.
No.
Thank you for everything.
Thank you.